Okay, conscious of time and seeing that quite a few people have joined already, I will start by welcoming everyone and thanking our speaker today, David Rouch, and our discussant, Professor Chiu, for being with us today. I have had the great pleasure of working with the two of them for a very long time. And in addition to being esteemed colleagues, they're also very good and dear friends. So let me start by saying that the London Financial Regulation Seminar is an intercollegiate and interdisciplinary group of experts, which is these days led by the Centre for Commercial Law Studies and our Institute of Banking and Finance. I'm the director and Daniele D'Alvia is the deputy director. The series started at the London School of Economics with my mentor and maestro, Professor Charles Goodhart. And then we took the baton when he became less active. He's still quite active, but less active with the day-to-day running of this London Financial Regulation Seminar. So I'm delighted that the presentation today will be the latest research paper by David Rouch on the individual, it's a long title, so allow me to read it. The individual, so that I do it well, the individual action dilemma, do fiduciary legal duties require them to consider action aligned with society-wide sustainability efforts, even if they cannot show a measurable benefit? And I will just briefly introduce David for those of you that perhaps know him less than I do. He's a very renowned expert in financial services regulation. He became a partner in Freshfields in 2004, and he has advice on the full range on financial market participants and transactions and regulatory bodies. But in the area that he's going to present today, he has also been very active and has worked with a number of international and national organizations. And he has written prior to this paper, as well as other papers, the book that he published in 2020, on which actually we also had a session of the London Financial Regulation Seminar. And the title of the book is The Social License for Financial Markets, Reaching for the End and Why It Counts. So he's very interested in a theme that actually brings him, Iris, and myself, as well as Daniel, together, which is the interaction of law and ethics, as well as the interaction between the private and the public sector in this domain. Let me just briefly introduce my friend and colleague, Professor Chiu, who is a professor of corporate law and financial regulation at UCL, University College London, and she's also an academic member of the Center for Ethics and Law and has done very significant research on banking, financial and fintech, the crypto economy, and the governance of business generally, and has published a number of books in these areas on the interaction between corporate governance and financial regulation. So without very much to say, just to say that David's research paper, as we put in the brief summary that with which we advertise the event today, addresses the individual action dilemma facing fiduciaries such as company directors and pension trustees under English law. And in the context of the debate, the ongoing debate, perhaps with the changing geopolitical climate, we are giving less importance to something which is one of the defining issues of our time and that we cannot ignore or continue to ignore. And that is that climate and sustainability threats, they jeopardize the economic and political systems upon which all market participants depend. And directors and trustees may be uncertain whether their fiduciary duties permit action that supports broader societal sustainability. And this is the issue that David is going to discuss us today. I will not go further into it so as not to take more time. I'm strict that it should be less than 5 times for the introduction. And I can see that we're already into 7:05, 5:05. So with further ado, I will silence myself and then I will give the word to David. Immediately after that, I will give the word to Iris before opening the rest of the discussion, whatever minutes we have for Q&A, which you can put in the usual way, writing the questions in the chat or raising your hand, and I will moderate the discussion. So thank you very much for being with us, particularly David and Iris, but also all the participants that have signed. And I will silence myself as I give the word to David, and I will ask all of you to silence yourselves.
Well, thank you very much for that introduction, Rosa, and it's obviously a great pleasure to be speaking this afternoon. Company directors, pension trustees and other fiduciaries face a dilemma over whether to commit their organisations to the project of tackling sustainability challenges to economic systems. Now, one approach to awkward dilemmas is to try to ignore them, hoping that they'll go away. As I demonstrate in my paper, referencing 3 recent cases, Client Earth and Shell, McGaughey and USS, and Butler Sloss, that option isn't open to company directors and pension trustees under English law. Shell and McGaughey both involved an application to take derivative proceedings against company directors for breach of duty regarding their handling of climate change, and the court declined permission in both cases because it wasn't satisfied that the claimants had established a prima facie case. So the courts didn't assess in depth what the directors had done to discharge their duties, but the court's approach is nonetheless instructive on the issue that I'm focusing on today. Butler Sloss concerned the trustees of a charity, and the charity had the environmental protection as its objective. At the trustees' request, the court did assess whether adopting a policy of transitioning out of investment in carbon-intensive companies was consistent with their duties. While the case concerned a charitable objective of environmental protection, there's still potential overlap with company investor goals where those are threatened by a failure of environmental protection. So, in the light of those cases, I'm going to comment shortly on where the law currently points trustees and directors, let's call them officers for the current purposes, on the issue of systemic climate threats. But before doing that, we need to be clear, 1, about the nature of the dilemma facing them, and 2, how companies and investors can approach systemic threats in practice. And I'm going to concentrate on climate change, where knowledge and practice are most advanced. First then, the dilemma. Climate change threatens the resilience of economic systems that companies and investors depend on to achieve their financial and commercial goals. There's a range of opinion on the extent of the threat, but I'm going to ask us to take it as read that the damage from climate change could be potentially serious, for example, based on the work of official bodies such as the IPCC. Officers' duties task them with pursuing the financial and commercial goals of their organisation. So on the face of it, they can't ignore this. But there are 2 issues. First, these threats fall outside traditional planning cycles of individual organisations. Second, addressing them requires a society-wide response to be successful, including a transition to a more sustainable pattern of production and consumption. So it might seem that individual organisations can do little on their own to reduce the threat. There may be commercial opportunities in the transition, but an organisation's individual action can't measurably reduce the threat. We have, therefore, a threat that needs addressing, but those who are threatened, viewed individually, appear to lack agency. Consequently, some officers might conclude that the threats are too far out, that acting would waste organisational resources and damage profits, and that their legal duties therefore prevent it. But as my paper demonstrates, that isn't so. Rather, officers' duties prompt action. Now, before explaining why, it's useful to understand what market participant action to tackle systemic sustainability threats might look like. So second, what distinguishes systems-focused action? There are two basic approaches to organizations facing climate risks and opportunities: idiosyncratic and systemic. Idiosyncratic action has dominated until fairly recently. Now here, a market participant looks at its climate-related risks and opportunities and changes its own position as best it can to address them. For example, a bank might manage its credit risk by reducing lending to companies highly exposed to climate risk. Much climate-related ESG integration works just like that, and it's simply good business. It doesn't really create any individual action dilemma. But what of systems-focused action? Well, this is quite different. Here, an organization recognizes its dependence on economic systems that are threatened by climate change. In consequence, it decides to act in ways that contribute to wider efforts to transition to a more sustainable system, seeking to change not just its own behavior, but that of others. Net zero transition plans are a good example of this. Transition plans partly help an organization navigate through the wider transition, but they also involve an organization doing its bit to ensure that the transition actually takes place. Viewed individually, the organization's action will have little measurable effect on the threat, but the challenge is systemic, requiring a widespread response. So from that perspective, the action contributes to the transition to a sustainably resilient economic model on which the organization's future success depends. All benefit, including the organization. So that's the dilemma, and then also the nature of systems-focused action. Moving on now to the guts of the issue, how does the law prompt officers to respond? And I'm going to break this into three parts. First, the basic duties. Second, time horizon convergence between systemic climate threats and the scope of legal duties. And then third, how officers' legal duties prompt substantive attention to threats within those horizons. So first of all, officers' basic legal duties. Very broadly, officers' duties are to weigh risks and opportunities pursuing commercial success, or in the case of pension fund trustees managing their investment portfolio, financial outcomes. For company directors, the principal duties, as we know, are to act in a way that the director considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, and to exercise reasonable skill, care, and diligence. Pension fund trustees, their duties and powers need to be understood in the context of the purpose of their trust, broadly to pay pensions for which they have to generate funds. Powers must be used for that purpose, and trustees must exercise essentially reasonable skill and care in doing so. The principal investment duty of pension trustees was summarised by the Law Commission as balancing risks against returns in pursuit of the best realistic return over the long term. Moving on, second, how do the time horizons suggested by those duties converge with the timing of climate threats? Well, for most market participants, systemic climate threats seem likely to bear most severely on medium and longer term periods, and those are easily within the scope of officers' duties to pursue organisational success. Officers can't just ignore them. Let me unpack that. Shell, McGaughey and Butler-Sloss all reflect this. So starting with companies. As I said, directors have a duty to promote the success of the company for the benefit of members as a whole. The interests of a solvent company for these purposes have traditionally been equated with its members, present and future as a whole, so that different cohorts of shareholders should be kept in view. And further, in pursuing a company's success, what Section 172 of the Companies Act requires directors to have regard to the long-term consequences of any decision and the need to act fairly between members. Consistent with this multi-time horizon approach, UK Financial Reporting Council guidance on Companies Act strategic report preparation emphasises the need to address short, medium, and long-term time periods. Apparently reflecting a medium to longer-term perspective, both Shell and the USS trustee and McGaughey had adopted targets that involved seeking to align activities to some degree with the Paris Agreement goals. There was no suggestion in either case that doing so breached the officer's duties. Indeed, it was taken as an indication of discharge. While McGaughey concerned the duties of the directors of the corporate trustee, USS, of the university's superannuation scheme under the Companies Act, the relevant activities were also intended to discharge the trustee duties of USS as a pension trustee. So USS was therefore taking an apparently long-term perspective on systemic risk in discharging those trustee duties as well. The time horizons for pension trustees will depend, among other things, on the age profile of their beneficiaries, but schemes often have younger beneficiary cohorts so that systemic climate threats are obviously relevant considerations. Where there are different cohorts of beneficiaries, trustees have a duty to exercise their powers in the best interests of the present and future beneficiaries, holding the scales impartially between different classes. They can't effectively disregard the interests of those with benefits in the longer term. UK statutory rules for pension scheme trustees requiring a statement of investment principles reflect that. The statement must cover the trustee's policy concerning financially material considerations over the appropriate time horizon. Appropriate time horizon here means the time the trustees consider is needed for funding future benefits, and financially material considerations include climate change. The governance and reporting regimes for larger occupational pension schemes also require identification and management of climate-related risks over short, medium, and long terms. Now, steps needed to pursue organisational goals by reference to multiple time horizons may differ as between horizons and potentially even conflict. An organisation can't just ignore the world as it is, including current investment market behaviour, to pursue the world as it needs it to be for its longer-term success. Among other things, doing so could prejudice its survival to inhabit that future world if it results in financial detriment. And the need to balance between those two, various horizons is reflected in the discussion of the court in Butler Sloss. So, that's time horizons. Systemic threats are likely to be within relevant time horizons for many, if not most, officers. Once that's recognised, what does the law prompt them to do about it? Well, at this point, it's useful just to take a step back and look at the wider context in which courts and officers are approaching this issue. What officers' duties require is circumstance specific. And with climate threats, the current context includes apparent hostility to attempts to tackle climate change from part of the US political spectrum, and that's echoed elsewhere. And that undoubtedly adds to the complexity facing officers. But beyond that is a widespread recognition of the need for individual actors to align with collective efforts to transition to a more sustainable economic system. Now, consensuses of this sort can have a significant bearing on the scope of legal duties. They can frame the way that officers' activities are viewed, including by judges, and respected bodies of opinion can also have a more specific influence on judicial decision-making. For example, in Butler Sloss, the court accepted that the broad goals of the Paris Agreement could be used in formulating the trust's investment policy. So let's just dip very briefly into the nature of this widespread recognition and then look at how far the courts adopted it in Shell, McGaughey and Butler Sloss, and I'll then distill the implications for officers seeking to discharge their duties. First then, the widespread recognition. There are widespread institutional expectations that individual organizations need to act on systemic threats, starting with the UN Framework Convention on Climate Change and the 2015 Paris Agreement, but then international bodies, including the IMF, the FSB, the Network for Greening the Financial System, the IAIS and IOSCO all recognise the need. In the UK, the UK's Green Finance Strategy is based on a similar understanding, and the PRA and the FCA both see an important role for individual institutions. Meanwhile, the CMA's Green Agreements guidance seeks to facilitate that. International and UK soft law standards embed similar expectations, and some are being given hard legal force in the UK and beyond. Now, we can come back to the ECHR, Klima Signorinen and Mille Défense and Shell if there's time, but probably the most notable international soft law standards here are the International Sustainability Standards Board disclosure standards and the Transition Plan Task Force disclosure standards. I mentioned transition plans a moment ago as an example of systems-focused action, but the ISSB disclosure standards also seek greater transparency about individual organizational exposure, both to systemic and idiosyncratic risks, and importantly, what the organization does to manage them. Now, for some UK operators, these standards are expected soon to convert to hard law. But even without that, UK reporting regimes already reflect expectations apparently consistent with individual systems-focused action. Trustees of larger UK pension funds are required to establish and maintain processes to enable them to manage effectively climate-related risks to the scheme. And there's statutory guidance on this, which relevant pension fund trustees are required to have regard to. And it explicitly identifies systemic climate threats as relevant considerations, recommending that trustees consider in their approaches to risk management activities such as stewardship, which could help reduce the impact of their scheme on a disorderly transition or systemic shock from catastrophic climate change. Turning to corporates, the UK corporate reporting regime reflects similar concerns, especially the requirement for larger companies to prepare a strategic report in Chapter 4A of the Companies Act. The strategic report is to help company members assess how directors have discharged their Section 172 duty to pursue the success of the company. So it could be expected to have some bearing on court assessments as well. The regime operates by reference to climate and environmental risks and opportunities, and those aren't just idiosyncratic, so that reasonably foreseeable climate damage to economic systems on which a company relies for its business is potentially in scope. And indeed, the Financial Reporting Council guidance on the preparation of strategic reports reflects that. The most stringent requirements apply to broadly traded companies, banks and insurers, but could influence wider good practice expectations. These companies have to disclose, subject to exceptions, the company's principal climate-related risks and opportunities and their timing, and importantly, a description of the targets used to manage climate-related risks and to realise climate-related opportunities, and of performance against these targets. The starting assumption here is apparently that a shareholder would expect to know what the company actually does to manage identified risks in practice. So those are the wider expectations. Were those understandings reflected in the approach of the courts in Shell, McGaughey and Butler Sloss? Well, simply yes. None distinguish clearly between institution-specific and systems-focused action, but in all three, the relevant officers had essentially considered and acted on systemic threats, and this was reflected in the court's reasoning. The relevant part of the Shell case concerned whether Shell was doing enough to pursue a credible net zero transition strategy based on its decision to set net zero goals. at least part of the framework of goals set by Shell for approaching climate risks, i.e. the thing that Planet Earth was challenging, rested on the need to address systemic climate threats. In particular, the Shell directors had adopted policies and targets to achieve net zero by 2050. In other words, a plan to transition. As the introduction to Shell's 2021 energy transition strategy stated, tackling climate change is the biggest challenge the world faces today. Our strategy sets out how Shell can and must play a leading role in helping society to meet that challenge. There's no suggestion that the court considered it unusual for the directors to have established net zero policies and targets. Indeed, it indicated that climate risk is a risk to Shell's business to which it will inevitably be exposed. More significantly, the court noted that the more important question is the nature of Shell's response to those risks and the directors' management of those risks. The fact that the directors had put net zero policies in place was said to be inconsistent with any suggestion that the directors have not in fact considered what is in the best interests of Shell and its members as a whole when addressing the most appropriate manner in which to deal with climate risk. The position of the directors might have been more vulnerable had they not assessed the risks and acted. In McGaughey, one complaint was that in addressing net zero, it was wrong to concentrate on the global perspective rather than taking a company's perspective, and that USS needed to have a plan for divestment. In other words, the directors had adopted a society-wide approach to acting counter climate risk. That included an ambition of net zero by 2020 and policies for working with investee companies to that end, which the court at first instance judged was well within the discretion of USS in exercising its powers of investment. The Court of Appeal agreed it was doubtful that there was a prima facie case that the directors had breached their duties. So again, evidence of a substantive practical response to systemic threats made it challenging to establish a breach. In Butler Sloss, the court specifically considered whether the trustees would be complying with their duties in adopting an investment policy excluding many investments they considered inconsistent with the trust's charitable environmental protection objective. Parts of their proposed investment guidelines had the flavour of a transition plan. While the motive was realising the trust's charitable objective, this was nonetheless, therefore, effectively a decision to take individual action aligned with societal efforts to tackle climate change. In the words of the judge, the claimants have decided reasonably, in my view, that there needs to be a dramatic shift in investment policies in order to have any appreciable effect on greenhouse gas emissions and for there to be any chance of ensuring that there's no more than a 1.5 rise in pre-industrial temperature. The only question is whether they have sufficiently balanced that objective with any financial detriment that may be suffered as a result. In my view, they have. Accordingly, the court made a declaration that the trustees had exercised their powers of investment lawfully. So, finally, where does this leave officers? What do their duties now require? Well, first, it's crucial to remember that while very important, what happens in courts is not all there is to understanding what legal duties require or permit. Officers are involved in an ongoing decision-making process directed at the success of their organisation, among other things in the discharge of legal duties. Court decisions are certainly part of the mix, but officers only rarely need to be forced to act by courts or anticipate court scrutiny. Increasing litigation risk is doubtless a powerful incentive, but legal standards influence behaviour in various ways, and among them is the relationship between legal duties and the mental frameworks that people use in deciding how to discharge them. And mental frameworks of this sort are clearly in play for officers facing systemic climate threats. Some may simply subconsciously dismiss the possibility of individual action, assuming that their organization can't make any difference and that in consequence the law wouldn't permit it. Others may consciously consider it but then dismiss it for similar reasons, and then still others may recognize the need for individual action but respond more timidly than is merited, again because of their organization's apparently limited influence or legal uncertainty. But widespread understandings of the sorts that I've just outlined, coupled with their progressive embedding in company and pension legal regimes, and the developing approach of the courts, bring a different mental framework to bear, emphasizing the need for substantive attention to systemic climate threats in officers' decision-making. While each decision needs to be taken on its own facts, climate change is likely to be relevant in deciding how to discharge officers' duties. At the highest level, officers need to consider A, whether climate impacts can reasonably be expected to bear on goals they're legally required to pursue within relevant timeframes, B, whether any impacts could reasonably be expected to be material, even if not precisely financially quantifiable, C, whether the impact is sufficiently likely to concern themselves with it, and D, if so, what they can do to mitigate the risks or benefit from opportunities. Risks can't be disregarded just because financial quantification is difficult. Materiality of impact and its likelihood need considering together. Something that could have a major impact can't be ignored just because its likelihood is considered low. Now, systemic threats from climate change would seem to be both potentially serious and foreseeable, though, even if the precise timing and magnitude are difficult to predict. But are officers required to accord them significant weight in their decision-making and act? What are officers actually required to do here? Now, clearly, Shell, McGaughey, and Butler-Sloss don't establish that officers are legally required to act in a particular way in addressing systemic threats from climate factors. English courts, as we know, are generally reluctant to apply that level of prescription. They consistently avoid reviewing the merits of directors or trustees' decisions in detailed decisions or their detailed business judgments, and instead they tend to focus on the robustness of the process and reasoning supporting a decision. And that was evident in all three of our cases. And in any event, the highly circumstance-specific nature of any action that a market participant might be able to take would make that level of prescription very challenging. But it is also clear that the courts recognise climate factors create risks and opportunities for market participants, including by threatening economic systems. And that leads in the direction of 3 A's: assess threat, assess action, and act. First, assess threat. Officers need to assess systemic climate threats and associated opportunities and the implications for the goals of their organisations. They're unlikely to be discharging their duties unless they do, not least because statutory reporting regimes for many companies and pension funds require it, and these requirements are due to become sharper still. Second, assess action. Where officers conclude, as might seem likely, that systemic climate threats bear on commercial or financial goals of their organisation, they also need to consider what they can do to mitigate the threat or exploit opportunities. Again, this is consistent with the expectations behind applicable UK disclosure and governance regimes, and again, officers are unlikely to be properly discharging their duties unless they do. As discussed in Shell, the court accepted that Shell faces material and foreseeable risks resulting from climate change, but it identified the more important question as being the nature of Shell's response to those risks. The apparent assumption was that the circumstances demanded a response. But third, must officers act? Now, it's theoretically possible that officers who've gone through the first 2 of those steps could take the view that individually their organisation can have no impact on system-wide threats and so shouldn't try. But that wouldn't accord with the widespread understandings that I've just outlined, and the English courts are highly unlikely simply to ignore those understandings in approaching questions of whether officers have discharged their duties. Consistent with that, in each of our 3 cases, recognition of the risks had led the relevant organisation to act in ways reflecting an intention to contribute to wider climate efforts. And in Shell and McGaughey, the derivative action might have been likely to proceed had they not done so. Indeed, while legal regimes need to be understood and applied on their own terms, the English courts have recognised the importance of individual action in tackling collective environmental challenges in other contexts. There is, for example, a strong line of 19th century precedent in the context of public nuisance, where courts granted relief against the polluting activities of one of a group of organisations, even where it wasn't possible to distinguish or measure the individual contribution to the nuisance, and even where the nuisance wouldn't cease if the relevant actor's contribution ceased. Notably, given the role of industrialisation in climate change, the nuisance in these cases generally resulted from the expansion of industrial processes following the Industrial Revolution. The cases remain good law, and indeed the New Zealand Supreme Court recently allowed a claim to proceed against multiple corporate emitters on the basis that the claimant had established a reasonably arguable cause of action, essentially based on those cases, and that's Smith and Fonterra. Clearly, officers can act. It's within the scope of officers' duties in appropriate circumstances to take individual action to tackle systemic threats relevant to organisational goals. Indeed, there are good reasons for thinking that they should, where 1, the action is reasonable based on robust processes to determine how best to contribute to the management of the threat and properly balances the financial risks involved, and 2, it doesn't so affect the shorter-term success of their organisation so as to threaten the likelihood of it being able to successfully inhabit the risk-mitigated world at which its contribution is directed. But have the courts reached a point where they will apply effectively a legal presumption that officers should act unless there are good reasons not to? As things stand, probably not. Currently, where a court is satisfied that broadly a decision not to act reflects what officers genuinely consider will promote the success of their organisation based on a robust process, and it's not outside the range of what a reasonable decision maker might conclude, the court is unlikely to impugn that decision given the subjective dimension to officers' duties and the court's reluctance to interfere in management that I've just been discussing. And yet, the changing context may well mean that when claims arise, courts will be more inclined to test the credibility of officers' professed justifications for conduct incompatible with the need to manage systemic climate risks. Especially following Shell, claimants may well do more to provide courts with the evidence they need to do so, and claims are likely to grow in sophistication. Further, expectations could quite conceivably harden if negative climate impacts continue to intensify as predicted. Circumstances will evolve, and the prospect of cases where officers are held to have breached their duties is growing. And it's already possible to imagine situations where officers could be breaching their duties if they don't act. So in summary, what duties require isn't limited to what courts might enforce in practice. But as things stand, based on recent cases, directors and trustees must properly consider the risks and opportunities for their organisation and how to respond in practice. Officers' duties leave them with discretion on what action to take, and a range of legitimate steps may be available. Whether officers decide to act or not, officers must base their decisions on a robust process, keep the position under review, and properly record their reasons. However, particularly in view of mounting litigation in this area, where climate factors pose a material threat to systems on which their organization relies, acting to address those threats may well be legally appropriate and advisable. Thank you.
Sorry, I was on mute. So now I have unmuted myself only to give the floor to Iris for her commentary. And Iris, she has some slides to share with us. So you have the right to share the slides, and I will go and continue to mute myself. Thank you.
Right. Thank you very much, Rosa. And thank you very much, David, for this wonderful presentation. I very much enjoyed reading the paper as well. And the role of the discussant often is a difficult one, because you have to try and pick what the gaps might be or what the holes might be, and to try and think of something that's thought-provoking. But you know that I very much agree with everything that you have said, and I think it's very important for us to be able to push for an explicit understanding of case law, that case law actually does support individual market operators taking action in face of the systemic threat that we have, and not just in terms of the idiosyncratic risks that they face. However, I mean, I still think that there might be a limit to what general law or case law can do. I mean, in terms of pushing the envelope. I think one of the ambiguities that remains is what you have pointed out on the issue of materiality, that whether climate change or broader, sustainability concerns are material to any business depends on the business itself. I mean, what the business is engaged in and what is financially material to it. And so, although there is widely accepted recognition that climate change is likely to be material to kind of every commercial outfit, very likely. And that in no small part, I think, is due to the effect of statutory obligations, so that reinforcing statutory obligation has become indispensable to our conception of climate change as being material. And I think a broader concern is whether any other sustainability issue or social issue might be regarded as material as well. And that probably depends a lot more on context. And so I think leaving general law to determine what might be material for business, and therefore obliges the duties on the part of market operators to consider them, leaves it to a very incremental form of development. But that said, I think a lot has been done in relation to climate change. And I also think that there remains some ambiguity in terms of how officers should consider, what to do in relation to an issue that is material. Because as you rightly said, it's up to them to consider the range of actions that they want to take. And Shell's transition plan, is up to 2050. And I mean, there have been recent reports about the acceleration, of global warming. And therefore, a question arises as to how urgent this might be, and whether it is good enough, really, to leave it to companies to consider their transition plans up to 2050 or beyond. So in other words, leaving that kind of discretion to individual action, brings us back into the idiosyncratic paradigm, isn't it, in terms of what they consider fit to do. I mean, I do see the point about not being able to overprescribe or micromanage what commercial organizations do. But I'm just wondering, in terms of, what the role of the law is in advancing any particular proactive actions on the part of commercial organizations. And in this respect, I mean, I think regulation has moved quite a lot more in relation to reinforcing the importance of certain sustainability concerns, as well as articulating the expectations of what to do. And in this respect, financial regulation has brought quite a lot more to bear upon the regulated entities. So the financial institutions, the banking sector, the investment management sector, the insurance sector. So this sector has experienced quite a bit more in terms of regulatory obligations that then push them forward towards more proactive forms of risk management as well as business strategy. And both the EU as well as UK regulation in this respect has achieved certain things. So for the EU, the Sustainability Financial Disclosure Regulation has often been cited to be the source for investment intermediaries to expressly integrate sustainability risks. And in that respect, one of the things that's achieved is that sustainability risks is not narrowly defined only to be climate change risk. I mean, it's much broader than that in relation to environmental risks broadly, as well as a range of social risks and to do no harm, to certain social as well as environmental and governance goals. So this is a broader embrace of a more holistic, range of concerns that society might care about. And the mandatory disclosure obligation, I mean, even though it's framed that way, does in a way push organizations to consider how they are going to integrate sustainability risk and how that might change their investment allocation behavior or their portfolio management behavior. So that pushes towards a greater form of proactivity, which then can shape or influence assets behavior. And the FCA's mandatory obligation for investment intermediaries is largely concentrated on climate risks as a result of the TCFD mandatory disclosure obligation. So it's a bit narrower in nature. However, I mean, that also spells out more clearly in terms of what sort of proactive monitoring needs to be done, what needs really to be taken into account of in terms of looking at the governance of risk, the control of risk, and the measurement of risk, as well as actions taken to mitigate risk. So one of the things I've always thought about, and I have discussed this with David, is whether there is an end to what general law can do, and regulation might be in a better position to introduce more proactive obligations that might push the envelope a bit further. And in relation to I mean, the papers kind of putting market operators together, officers together, pension trustees as well as some directors of companies. I'm just wondering, with financial regulation moving in a direction where it's much more explicit and imposing more proactive duties on the part of regulated financial institutions, are we seeing an asymmetry developing between financial regulations obligations and corporate officers' obligations under general law? And this might explain why in the EU there has been that increase in terms of corporate regulation, in terms of the CSRD, the Corporate Sustainability Reporting Directive obligations, the obligations for reporting under the taxonomy regulation, as well as the CSDDD. Although we know that the EU now has an agenda to kind of water down some of these obligations in order to address companies' complaints and their lobbying about excessive burdens that are placed on them. But yet, I think that movement has to be recognized for what it is. It is a movement to achieve a greater symmetry between the expectations imposed on investment management and financial management in general, and what the directors and the officers of assets of companies do. So whether this symmetry is necessary, how should it move together? And are we moving at the right pace in the UK? I think it's something that is possibly quite important. There is a paper that I would refer to, Professor Ian McNeill and Irene Marie Esser from Glasgow published a paper called From a Financial to an Entity Model of ESG, and examines that symmetry issue very well, and arguing that there should be a greater symmetry. And And I wonder what you think of it, David, because this is an opportunity for me to ask you about your thoughts as well, in relation to this, not just in terms of what you think about the relationship between general law and regulation, and also whether, you know, there should be less asymmetry between the expectations for assets and financial institutions. And I think finally on the issue of whether individual market operators' actions can be systemic in nature, I think we welcome, you know, this articulation that their actions can be conceived of as systemic and they should see themselves doing it this way. And I think for me, it's just in terms of operationalizing it, you know, do we think that a form of authoritative coordination involving more public policy, you know, would be beneficial? Or is this something that we think is best left to market operators' incentives? And I think what we are worried about being left to market operators' incentives is that there are always different dilemmas, you know, that are in the minds of market operators balancing various aims and strategies and objectives. And how would this then affect the sort of proactivity that we hope, you know, the commercial outfits can engage in order to address such an important issue of our time? So these are my brief comments. And like I said, very much enjoyed the paper, very much enjoyed your presentation, and really hope to hear more from you in terms of what you might think of these comments. Thank you very much, David.
Thank you, Iris.
Thank you, Iris, for this wonderful commentary and also for bringing the dimension of financial regulation on which you're all an expert and you have had deep thinking also in the paper that you just mentioned. David, there is a question in the chat. So I will read it for you if you cannot read it, or if you can read it aloud, you can read it yourself. It's from Deborah Dean from the Victoria University of Wellington. And she writes, do you have a view whether compliance or non-compliance with the FCA ESG disclosure requirements and any future regulatory requirements on ESG investing, including the differentiation between financial and non-financial factors, should be considered as having met any fiduciary or other common law duties on pension fund trustees and company directors, or to operate as a safe harbor to any private law action by beneficiaries against company directors or pension scheme trustee for a breach of fiduciary duties? And
I'm guessing that's a reference to the SDR rules for disclosure rules for sustainable investment funds. And though, if I'm right about that, those rules are really focused on a different scenario. So they're really focusing on investment funds that have got a parallel objective. So the discussion that we've just been having is looking very much at financially and commercially driven sustainable investing or sustainable activity. Those funds are essentially, that set of rules is to prevent greenwashing. And they're saying that where a fund uses the word sustainable in its name, then it genuinely has to be doing something to further sustainability, in addition, in parallel to any financial claim that it's making. So I'm not sure that those rules per se are going to enable to operate as a sort of a safe harbor for breach of fiduciary duty. What I do think is extremely interesting about them is, though, that they distinguish quite sharply between these two motivations for engaging in sustainable activity. And perhaps more importantly, in terms of discharging fiduciary duties, they are really, I think, going to operate as a bit of a laboratory for working out how you go about bringing about positive, sustainable outcomes. So I think they're going to, they're forcing funds that claim to be sustainable to look very, very closely at what they are doing to justify that claim. And so one might have thought, particularly because you've got firms like Schroders who have got non-sustainable funds and sustainable funds, you might have thought that there could end up being some kind of cross-fertilization in terms of the know-how that's generated in that context, which then becomes relevant to how fiduciaries discharge their wider duties in the context of financial return, which is threatened by declining sustainability.
Thank you very much, David. Would you like also very briefly to address any of the issues that, some of them challenging, that Iris
I'd love to, yes.
I know that you wanted to, and the paper that she wrote, I don't know if you have seen the paper that she wrote with Ian McNeill, but anyway, you have 2-3 minutes to do that, or even 5, because I think it was quite important, the dimension that Iris presented. So,
yeah. I mean, yes, basically. I mean, I think what we're dealing with is a complex adaptive system. There are all sorts of bits in the system that have a bearing on how people behave and what they do to discharge legal duties. And I think you will have seen, obviously, from what I've said, that regulation is very much part of that mix. The fact that we have these disclosure and governance regimes is, I think, relevant to what general case law is then going to be saying. So I think absolutely regulation is an essential part of the mix. Is case law too incremental? I mean, it is incremental, and so is regulation, and so is everything else. And I think part of the problem that we've got, even when you step outside the law, when you're looking at just the simple challenge of, well, how do we convert our system to renewables? Well, there are a whole load of interdependencies, and which force the change almost to become incremental. We cannot at the moment generate, we can generate more renewable electricity than we can actually transmit into people's homes. And to transmit it to people's homes, we need a workforce, and we haven't got the right skilled workers to build the infrastructure we need. So you've got and we've got the same thing going on with between law and regulation. As to whether there's a divergence between regulated firms and corporates, which I think is essentially what you're saying. I mean, my focus obviously here is more on pension fund trustees as the asset owners and the officers of corporates as the things they own. You then have the regulated firms in between, the intermediaries, the investment managers. And it does seem to me at the moment that the investment managers are in a sort of a bit of a regulatory no man's land, because a lot of this activity that asset owners are wanting them to engage in isn't really about stock picking, which is the thing that is most, is principally regulated by the FCA. And a lot of this isn't stock picking. It's more to do with engagement, stewardship, even political engagement, and joining net zero alliances or whatever. And those things aren't really covered by regulation. So in that sense, I think in a way regulation isn't ahead. It's almost falling behind. So I'm not sure that I think I'd want to reflect a little bit more on that. But I don't think it's a simple situation where you have a regulated space that is ahead of the corporate space. And I certainly think once we see the ISSB sustainability standards and transition plan standards introduced and getting a sort of a sharper legal edge, those I think are going to focus rather more on corporates than certainly investment managers. So if there is some catching up to do, maybe they will be a means by which that happens. But I think both are needed. You need the cases. I mean, heavens, the amount of discussion of fiduciary duties, the fiduciary duties have got totemic significance. And so people obviously do take notice of what people think they may or may not require or permit.
Thank you. Daniel had a question. Daniel?
Yes. Yes, I had a question essentially that maybe can connect a little bit David and Iris, in the sense that I wanted to know, if possible, what is in your view, David, the future of the future litigation or regulatory developments that can further clarify or maybe put pressure to fiduciaries to take active sustainability action, even though, as you said, exactly, the individual measurable benefits remain elusive. So I wanted to maybe have this question as a forward-looking statement.
Yeah, I mean, I haven't got any inside knowledge on this, but I think it's inconceivable that we won't have people having another shot at it. There is already, so there's one paper by Aristova and Nichols that is looking at possible strategies. We've had Lord Carnworth sort of almost encouraging people to have another go at it. And I think raising the question as to how whether the Supreme Court might be rather more amenable than the lower courts. Of course, Philip Sales has made a couple of speeches on this topic, and his most recent, I think, which was earlier this year, again, gives the impression that I think he is perhaps expecting this to come. So I think it's likely. When it will be in the UK, whether it will be in other jurisdictions, I don't know. I mean, obviously, for the purposes of our discussion, the crucial thing will be what happens in the UK or in the Commonwealth jurisdictions. And we'll definitely be watching the Fonterra case, because that's going to be extremely interesting on that topic. But it seems inconceivable that we won't have further litigation on this.
Yeah.
And I see Francisca has mentioned also a paper by Ellis Farron and Pedro Schilling,
Yes.
looking at this point that we've been sort of circling around on the relationship between what you might call process regulation, governance-focused disclosure, forcing organizations to look at their processes in a particular area of risk, and thereby nudging enhanced behavior. And I think it's a great paper. I'm going to be referencing it in my own, and I think it kind of makes this point that there is a symbiotic relationship between those two, regulation and case law, and you need both to move things forward, I think.
You actually do need both. You need, like you were saying, David, you need every layer that you can. Remember that 2 years ago, I was asked to consider what supervisors should do as different from regulators in the area of sustainability, and taking the acronym in the US that supervisors use to look at the different elements that they look when they look at mostly banks and depository institutions, which is CAMELS, capital assets management, earnings, liquidity, and sensitivity to market risk. I said a new S should be added for sustainability, so under that category. So I think, you're right to say that, case law and regulation should actually, we have so much more work to do in this area. So there are different layers, and I like that idea of a multi-layer approach. There is also other comments about another, Deborah Dean also has mentioned the Financial Markets Law Committee paper on pension fund trustees and fiduciary duties, decision-making in the context of sustainability, and then the forthcoming pension schemes that has the government's growth agenda at its heart. If I can say something about that, I have just been appointed in April as a specialist advisor to the House of Lords Financial Regulation Committee on the secondary objective of the PRA and the FCA, which is international competitiveness and growth. And some of the themes that both you, David, and Iris were saying, one looks at what can make the UK as a source of growth in a way that it's, it is, I should say, genuine and authentic, and trying to break ground in areas which really can contribute meaningfully. A lot of the things that you're saying can be included in an agenda for growth that makes sense from a financial sector perspective, as perhaps some other areas or not necessarily conducive to also the achievement of what remains the primary objective of those regulators. So anyway, very interesting in many areas. I have to say to this very interested crowd that has stayed all the way to the end, sometimes when we have these seminars, a lot of people start dropping out. I can see almost staying, that we will have another event, and this time it will be hosted by Iris at UCL, and then the further details we will need to iron it out for the fall. But please join me in thanking David and Iris, and obviously from the perspective of our London Financial Regulation Seminar, Daniele and I thank all the speakers for this wonderful session. So thank you very much.
Thank you. I've enjoyed it.
Thank you. Thank you.